Professor Evenly, we are now live on YouTube as well. You can start the webinar anytime now, sir. Thank you.
Namaskar. We are delighted to inform Symbiosis Law School Noida, in association with Lex Witness, India's first magazine on legal and corporate affairs, THS, the law firm, SADGAMAYA presents Knowledge Series on Law and Justice. The Knowledge Series aims to provide continuing legal education to the members of the bar and to provide an opportunity to the students of the law school to learn from the best and most experienced legal luminaries and have a first-hand experience of interacting with them. Today, we have among us Mr. Banerjee, Mr. Vikramjit Banerjee, Additional Solicitor General of India and Senior Advocate, Supreme Court of India, to speak on the topic constitutional morality. Indeed, a topic which never would lose its importance. So I would request Mr. Kumar Mihi, who would moderate the session for the day, to set the rules of the housekeeping to the audience. Over to you, Mr. Mihi.
Thank you, sir. Today we are indeed honored to have Vikramjit sir, who has given his consent to deliver his talk on this topic. Before I hand it over to Vikramjit sir, I would like to lay down the housekeeping rules. All the participants who want to pose questions to sir can put their questions in the Q&A box, which is visible on your screen, as and when the sir permits us, and we have the opportunity, we'll pose those questions to sir. If you want to ask live questions, you can use the raise hand icon, which is also visible on your screen. You can press that and we'll put you in the queue. And at the end of the session, we will allow you to ask your questions directly to sir. So without further ado, I would now like to invite Vikramjit Banerjee sir to start the talk. Over to you, sir.
Thank you. Thank you for giving me the opportunity to speak at this very, very prestigious lecture series, webinar series, whatever one calls it. Sometimes I think that there are some positive points of the lockdown, horrible as though this year has been, but it has allowed us to maybe virtually meet a lot more people than we usually get an opportunity to meet. So I, again, thank Symbiosis for giving me this opportunity to address its students and faculty and people who are involved in this webinar. And thank you again. And I hope you get to at least this talk, which I intend to give. I don't consider it as a lecture. It's not. I don't consider it much. I don't give it more importance than what it deserves. It's a talk. And I hope it gets you thinking. It's not meant to be a criticism of anything, though I'm sure it's going to be a little controversial because, as Mihir knows and Sir or Professor also knows, that I'm known for keeping a little bit of a controversial points of view. So I will put forward whatever I have to say, and I welcome questions. It's not that I have answers to every one of those questions, but we'll try to figure out our way through what my impression about those issues are. Coming to the talk now. The question which broadly sort of we are addressing, and that's the topic of this discussion and this talk, is constitutional morality. Now, we are all hearing very regularly of constitutional morality. We hear it in the press. We hear it very frequently now in judgments of the Supreme Court. We hear it in discussions like this. We hear it in school, in class, in law school, possibly in the cafes, canteens, and everywhere. Constitutional morality is a huge thing. I don't attend school regularly. I don't attend law school regularly now. I have a different job. But
Sir, you're on mute.
Mr. Banerjee, you're on mute, sir. Could you please unmute yourself? Mr. Banerjee? I'll be unmuting you remotely now, sir. Mr. Banerjee, we lost you for last 15-20 seconds. By
Okay.
mistake, you were on mute. Request you to
Okay.
please start again from
Yes.
that moment of time, sir. Thank you.
Okay.
Over to you, Mr.
So
Banerjee.
I think it's very, very crucial that we sort of understand these issues of constitutional morality, which may be agitating us, which may be the scope of great debate in uh, amongst the law schools, amongst people who are interested in constitutional law, because this will not only be relevant now, this will be relevant also for the future. That being said, now what is the origins of this conception of constitutional morality, the term constitutional morality? Where was it first framed? Who were the people to come out with it? The first known, and it's widely accepted because Baba Sahib Ambedkar also quotes this, and I'll go into that, is by the English historian Grote. Now, Grote was an English historian who was a specialist. He wrote a multi-volume book on Greek history. Now, as we know that the European tradition traces its belief in constitutionalism, in democracy from Greek history. And Grote wrote this extensive sort of history of Greece, of ancient Greece, in which he discussed as to why maybe the Greek states, the people, citizens of Greek states, or states like Athens, of Sparta, why didn't they have, why wasn't there anarchy? How come they all remained together? Because all of us know that, governance sometimes degenerates into anarchy, breaks apart. So Grote was of the view that the principal reason for that was the conception of constitutional morality. Now, he defined constitutional morality at the keystone of this understanding of democracy, of this understanding of Greek rule of the people, where he said that both the opposition and the government actually believed in these institutions of governance. So even if I lost an election, or even if I was on the losing side, I respected these institutions so much that I did not want to break them apart. And he said on the flip side, the government, people in government would sort of respect these institutions so much that they would not subvert them, they would not destroy them when they were in a position to do so. So he said the belief of constitutional morality actually existed within the people. And it's like the people's belief in an idea that these are institutions which are key to the governance of this country, which key to the constitution. So this is an idea which came with Grote, and Grote sort of came up with that at the time of when he wrote this book on Greek history. Now, Baba Sahib Ambedkar at the Constituent Assembly, during the time of discussion of the Constituent Assembly, again talked about what sort of a state are we looking at? How long would our constitution last? What is the importance of a constitution? These questions were like greatly talked about at the Constituent Assembly. And because these were relevant questions, because for the first time we were coming out with a constitution, even though we had Governments of India Act, which we could today construe as constitutions. But for the first time, people of India were getting together and forming this constitution. And the biggest question was, we are a very diverse state. We were a state with very many different kinds of people, class, religion, region. So how do we make it work? And Baba Sahib Ambedkar very, very interestingly quoted Grote and said that, in the end, what is required is this idea of constitutional morality. And we have to, and he said it very clearly, that we don't have constitutional morality. Constitutional morality has to be cultivated. So it's something which is a deliberate process. It is a process whereby people have to be taught, or in some ways cultivate this feeling that people should respect the institutions of governance. And that's how the idea of constitutional morality sort of became a part of our constitutional thinking. Now, there are another way to look at constitutional morality. The other way to look at constitutional morality, and this is in context of maybe in terms of how the British actually interpret constitutional morality and brought it as part of their uh, own forms of governance. Because as we all know, we inherited our system of governance from the British. The British interpreted, and this was Dicey, this was Ivor Jennings, they interpreted constitutional morality as parts of what in Britain is known as the unwritten constitution. They were the hidden understandings of the constitution, the sort of understandings which were amongst the people. Understandings, because we all know large parts of British constitution was unwritten. There was an unwritten understanding that if a government lost an election, then it left. There was an unwritten understanding that elections were to be held. These are revolutionary things at that point of time. Because at that point of time, the only way you could actually get rid of a government is if you sort of chopped off their heads or if you removed them by force. So the fact of, so various different things, and this is just one of them. There are a large number of precedents. There are a large number of the fact that you respected a decision of the court, that the people respected the decision of the court, that the governments respected a decision of the court. Now, were revolutionary things. Now, all of us who have an idea of constitutional history and know that even in American law, for that matter, American constitutional law, which was largely written, Marbury versus Madison, which came out with this conception of judicial review, was like revolutionary, which wasn't conceptualized in the Constitution. But the fact that the government would have to follow a decision of the court, and the decision of the court was binding on the government, and the court could sort of declare a law passed as or an action of the government as unconstitutional, was unheard of. But the fact that this was unwritten, the British considered this conception of unwritten understandings amongst the people of institutions of governance as constitutional morality. And there was a large amount of literature also on that. Now, I think the first major case which sort of decides, which sort of brings constitutional morality into play, into a subject of discussion, was naturally Keshavananda Bharati, because the case was as such, because it was discussing the constitution, it was the context of the case, it was in times of emergency. There have been large amendments to the constitution, which it was judging. There was a very, very strong government. Some would even call that government in many ways dictatorial, very powerful government. And the court was under a very tricky situation. So that then the court then came out with this conception of constitutional morality. Though it finally didn't rely on the conception of constitutional morality, but when it discussed constitutional morality, it actually treated constitutional morality in the terms of the very British terms. And I say, and I'll take this at a later point of time, is when I say that it treated constitution in a very British terms, or for that matter, in a very conservative method. A conservative method would be, as I said, the hidden understandings that people respect institutions. While, as we will discuss later, sometimes constitutional morality has been used by the courts in sort of revolutionary terms, in terms of individual rights, in terms of the American conception of rights, of the rights discourse. But Keshavananda Bharati uses this conception of constitutional morality, as we see it, as a conservative doctrine, as a doctrine whereby people respect their institutions. Now, the next big matter is Captain Virendra Kumar versus Shivraj, where again it discussed this, as I said, it discussed this conception of constitutional morality, especially in common law. And it quoted, as I said, one of the greatest British thinkers of law. It talked about Dicey. And it discussed the fact that even though law is made by written and unwritten rules, it's the hidden understandings of the people of the constitution which is extremely important. The next matter, again, where constitutional morality was discussed by the Supreme Court, was Islamic Academy of Education. Now, all of us know Islamic Academy of Education was in relation to minority rights, and minority rights, interpreting what is the right to education, etc., of minorities to run their own educational institutions. Now, this is for the first time where this dichotomy starts coming into effect, which sort of later plays out and which is played out hugely now. Islamic Education Society, the court for the first time, interestingly, brings forward the conception of equality. Now, while all of us know Islamic Education Academy of Education actually extends the right of a similar right to the majority, saying that, you know, these rights, right to carry on, start off your own educational institution, etc., can be extended to the majority. But it talks about this conception of equality. And for the very first time, and this is very interesting, for the very first time, it sort of says equality of treating different people is part of constitutional morality. Now, it seems an innocuous sort of a change at that point of time, but today you will see how much of an impact it has on jurisprudence subsequently on Supreme Court's thinking. The next major case was Manoj Narula. Now, Manoj Narula was in relation to deciding as to, you know, exercise of power and exercise of government and how it exercised power. And this is, I think, one of the cases in which constitutional morality was discussed was discussed in great detail. Now, the crux of what the Supreme Court held in Manoj Narula, and this is very interesting, the crux of what Supreme Court sort of discusses and holds in Manoj Narula, it says that people who exercise power should believe in constitutional morality. And he says the only way you can sort of protect the Constitution if people who sort of exercise power are inculcate constitutional morality and sort of act in the ways which is constitutional. And, you know, so that people themselves don't act in a way which is unconstitutional. So it is incumbent upon the powerful to act in a way which is in accordance with the Constitution. Again, this is strictly outside the conception of what constitutional morality in terms of English common law, but it is an innovation of the court. It now means basically in the 80s what it was, as all of us who have an idea of the jurisprudence of the court in the 80s, the court starts sort of considering that for every right you have a Hoffeldian duty, as in you have the commensurate opposite duty. So because there is constitutional morality in society and you expect all the people to respect that constitutional morality, the court also believed that the people in governments therefore had also a duty to inculcate constitutional morality amongst themselves and not violate constitutional norms. After this was, of course, where constitutional morality was discussed in even greater detail, was Shaira Banu. Now, Shaira Banu is, of course, better known as the Triple Talaq case. Now, in Shaira Banu, most importantly, when the court was asked to decide on constitutional morality, it discusses constitutional morality in great detail. It says, the court should follow constitutional morality. It's extremely important that constitutional morality should be cultivated amongst the people, and every sort of case should be tested on constitutional morality. It is for the first time, I think that Shaira Banu sort of lays the foundation of the great expansion of constitutional morality that we see today. But ironically, and this is extremely ironical, that in the end, Shara Banu is not decided on the basis of constitutional morality, as we all know. It was decided on the fact that, on the grounds that, as the Supreme Court famously said, that what is not good in religion, what is not good in theology, as Justice Kurian said, is not good in law. And it also sort of did not strike it down on the grounds that it went against the fundamental rights. Triple talaq was not found violation of fundamental rights. So, but it was on the fact that it was not an acceptable, or was not a part of, to that extent, was not accepted as an acceptable part of Islamic law, and to that extent was struck down. Shara Banu, again, ironically, doesn't answer, doesn't test triple talaq eventually. After going through this huge lecture on constitutional morality, does not test triple talaq on constitutional morality. It avoids that question. It does not address that question at all. So you would expect that that is what would be the final sort of outcome of Shara Banu. And it's a question which would have struck everybody. And rightly, it struck the court, but the court didn't answer it. The next place, I think that was the, as they say, the perfect storm, was where constitutional morality was discussed in even greater detail. And this is all Shara Banu, as you know, triple talaq onwards, is the latest court as we see today, was the National Capital Territory of Delhi versus Union of India, which sort of decides what is the constitutional status of Delhi. And again, obviously, to sort of discuss who exercises what power and to what extent, et cetera, et cetera. There was a large discussion of constitutional morality, and that both the people, all people exercising power should be subject to constitutional morality. They should exercise constitutional morality. They should have constitutional morality, and so that was also discussed in great detail. And the crux of the discussion of what we can take away from the National Capital Territory of Delhi case is that people said all constitutional functionaries, as again, which was discussed, always been the view of the court, should encompass, all constitutional functionaries should have constitutional morality, and especially for high constitutional functionaries, and should exercise constitutional morality. And that includes, and this is very interesting, it includes governance, it includes institution building, and it includes what is famously called a constitutional balance. He said constitutional balance, the maintaining of the fine balance between different institutions, is part of constitutional morality, which to us, is different from what constitutional morality originally started off with, but is possibly an outcome of the way the court took down the road of constitutional morality in the 1980s in the Islamic education and in Manoj Narula. But, and here is the crux of what becomes this huge question which we all face, which we are facing with constitutional morality today, is in paragraph 297 of that judgment. It sort of prescribes, there is this huge paragraph where it prescribes constitutional morality as the basis of social revolution. And this is something which becomes a flood in Navtej Singh Johar, which becomes taken up in the adultery matter, and then finally comes to a head in Sabrimala. So in Navtej Singh Johar, so that's what happens in National Capital Territory of Delhi, where in paragraph 297, the court suddenly takes off and says that, it is the prescription for a social revolution. Now, that's taken up in Navtej Singh Johar, in section 377. Now, all of us are aware of context of Navtej Singh Johar, so I will not discuss that in great detail. But what happens in Navtej Singh Johar is Mr. Arvind Datar actually comes up with an argument. And when he makes that argument, he says that, that social morality is different from constitutional morality, because he was sort of arguing against the fact that 377 has been construed to be socially moral, so it's been upheld. So, but the conception of 377 is maybe socially acceptable, but it is against constitutional morality. So he sort of mixes a very interesting thing. He makes an argument saying social morality should be overruled by constitutional morality, and he equates social morality with majoritarianism. Now, this again becomes a huge part of the court's thinking in subsequent orders. And this leads to the conflict which takes over the court in Sabrimala, which it is absolutely directly just goes down that road. Now, the court says in the end, the court sort of takes the entire logic of Mr. Datta, and it does say a few things. It says that, constitutional morality overrules social morality. And again, it uses that entire question of social morality and majoritarian in nature, etc., etc. Two, it says, how do you, how do you test what is constitutional morality? What is constitutional morality? How do you come to a conclusion of what is constitutional morality? Because constitutional morality is a generalized concept. And the court then comes out with the formulation is that the mandate of the protection of human rights and the mandate of protection of individual rights is constitutional morality, which is in effect, if you read it with the National Capital Territory of Delhi case, which is a prescription, and para 297 speaks about, it's a prescription for social revolution. This completely feeds into that, saying that, you have to effectively have, individual rights, and who interprets those individual rights? But the judiciary. So the individual rights are a prescription for constitutional morality, and constitutional morality can overrule social morality. Path breaking, and it goes down a completely different route from what originally constitutional morality was sort of conceptualized as. Now, this next goes into the famous Joseph Shine matter, which discusses, again, the court similar. It's in the composition of the bench is similar. In section 497, which talks about adultery, and it absolute, takes down that same argument about, social morality, constitutional morality, individual rights, majoritarianism being part of social morality. And which leads finally into Sabrimala, where these two ideas clash. Because when Sabrimala comes into effect, now we all know Sabrimala, the basic predication of Sabrimala is there's Article 25. And one of the restrictions of Article 25, you have a right to religion, is that you have, public morality is a restriction on right to religion. Now, so how do you address this question? Now, the court was in Sabrimala, as we all know, was trying to balance two competing fundamental rights. One was the right to religion. The other was the right to equality. So the court, while trying to link both of them together, had to interpret this conception of public morality, which could be read as a restriction on the right to religion. Because if it had to sort of adopt the argument that in some way equality overruled your right to religion, then it had to come within one of the constraints, one of the restrictions on the right to religion. So it sort of addressed that question of public morality, which was part of the restriction on right to religion. In doing that, the court came to this entire conception that public morality is not a public morality, but public morality is constitutional morality, which means individual rights, which means individual freedom, which therefore, if you go straight on backwards, leads to prescription for social revolution. Now, My view, of course, on that is uncalled for. Created huge amount of controversy, created cleavages in society, almost managed to create kick off a revolution in parts of India. But the fact is that the Supreme Court completely interprets constitutional morality very differently from how Keshavananda Bharati actually interpreted constitutional morality, takes it on a different path. And today it has become the sort of the object of discussion in law school. It's because the question which arises is whether constitutional morality can be a prescription for social revolution. Now that is discussing the sort of case law part of it broadly. Now, coming to the ideas of constitutional morality. Now, the idea of constitutional morality, I've been parts of some of the discussions which have gone on, out of the courts. Different people have different sort of says on it, different voices on it. But two of the major people who were critical of that, I know personally. One is the present Attorney General, who has on a number of occasions, even before Justice Deepak Mishra, who was one of the biggest proponents of constitutional morality at a seminar, actually spoke about, Mr. Venugopal actually spoke about how constitutional morality was an unruly horse. And he was very, very skeptical of constitutional morality because it gave too much power to the courts to interpret constitutional morality in whichever way it sort of wanted to, give too much discretion, and he wanted to be clearly defined. Professor Menon, the late Professor Menon, Madhav Menon, was also, when he was, I remember that when being asked to discuss in constitutional morality, was also very skeptical. He was very skeptical of the fact that you can come out with a generalized concept of constitutional morality, and what does it actually mean? What does it have to be? Where is it leading to? But that being said, what is my view? What is my view on constitutional morality? And here comes the entire controversial questions. My first question is, something which we all need to ask ourselves is, who decides what is the content? What is the content of constitutional morality? Which overrules social morality? Which overrules public morality? This is something which we all need to sort of think. Who decides this? Because at the end of the day, does the judiciary decide this? Because who constitutes the judiciary? And I always say this: who constitutes the judiciary? Judiciary is constituted by people like us. People like us means people who've been to similar background, people who've been to a law school, people who have studied or adept at English, people who are in many ways, in some ways more, some of us less, but deeply accultured in Western ideas of society, of governance, etc., etc. The rest of India is fundamentally different, works very differently, and the application of these ideas of constitutional morality creates more problems than it solves. We know, and this is an interesting aside and something which we should keep in mind, that possibly one of the reasons why Shaira Banu or triple talaq was more acceptable in some ways in portions of the society in which it was applied was because Shaira Banu actually gave up, or did not address the constitutional morality. So did not say that triple talaq was against constitutional morality, because that seemed to be, because the court seemed to be consciously avoiding the pitfall that it had in previous matters involving Islamic law, where Islamic law was tested on the constitution, and there was a huge backlash. So the court actually did not address that question at all. And that seems to be one of the reasons why people were more accepting of it when it was argued that this idea is not acceptable in Islam, so it's not a practice which is acceptable. So to that extent, it is unconstitutional. It was struck down on that ground. But in the case of Sabrimala, the court adopted a completely different view, completely different line of argument, and which created the huge problem, the cleavages, the anger, the resentment of saying that your practice. I think the court could have, and there was enough material before the court, I think, which could have said that the practice of exclusion was not necessarily, of that ancient origin which it was being made out, and maybe there were enough religious books or religious sanction to have come to a different interpretation. But the court chose to sort of strike it down across the board on the ideas of constitutional morality, which according to me, had huge repercussions, which we all saw. The other is the broader question, and this is a question which we all need to understand and need to think about, is how do we approach our constitution? There are people who believe that our constitution is a prescription, is a manifesto for radical change. And for the want of a better word, I would say they sort of contribute to the American revolutionary belief of constitutions being, of French American revolutionary beliefs of constitution being the prescription for change in societies. But according to me, our constitution, and Baba Sahib Ambedkar was also of the view, was value neutral. It didn't want radical change. It wanted the status quo, but it wanted the status quo to be governed well. So therefore, our constitution was framed. So it wasn't actually a transformative constitution in that respect, because it came, as all of us know, it came from a series of government. It's an inheritor of a series of Government of India acts in many ways. The only part of it was, fundamental rights were incorporated. In many ways, I like to sort of treat the constitution as largely a conservative document. I use the word Burkean because it was Edmund Burke who at the time of the French Revolution sort of came out with this conception that the work, while on one hand people were propagating that constitutions, whether it be in America, whether it be in France, which were at forefronts of revolution, was a prescription for wholesale change, Burke was of the view that constitutions were to govern the status quo in a better manner, in a manner which was which incorporated change, but incorporated change slowly. So it is my view as to how do you interpret the constitution? Do you interpret the constitutional document as a transformative constitution, as a revolutionary, as constitutional morality, as a prescription for social revolution, or do you sort of treat the constitution as a document which sort of ensures the different groups of people have come to a compromise? And this is something which we have to work through. It is also to incrementally make us better as a people and to ensure that rights are protected. And where do we what do we actually believe in? And do we believe that the rights in the preamble, the fundamental rights, overrule other parts of the constitution? Or do we have a more balanced approach, which seemed to be the view of Keshavananda Bharati, which seemed to be even in the minds of Baba Sahib Ambedkar, and which is sort of the Burkean way of looking at the constitution? I would obviously take the view that maybe the problem with using the constitution as a prescription for social revolution is that it does not take into account the diversity of this country, the ancientness of this country, the history of this country, the culture of this country. And that is why I'm very fond, the part I'm very fond of quoting in Sabrimala, and the part which I always highlight in Sabrimala is the dissent of Justice Malhotra, where Justice Indu Malhotra actually says that, you know, we need cultural constitutionalism, where she talks about, you know, you need the culture of the people rather than a transformative constitutionalism. But we need a cultural constitutionalism which takes into the culture of the people. And this culture of the people, as I always say, has changed over a period of time, but it changes slowly. It doesn't change overnight. And it definitely cannot be changed by people like us who are like who we are, products of our own background. And therefore, change has to come from below and not from the top. You know, now coming towards the end, we also have to realize it's incredible. It's very important because we are products of who we are. We also have to realize that we cannot replicate Western societies in India. We have to keep into context who we are, where we come from, and where we can go. It also talks about the uniqueness of who we are as a people, our diversity, our cultural heritage, as I discussed. So it is not in our interest, and it's never worked in India to go for radical prescriptive revolutions. Revolutions in India have never worked. In its history, there's never been revolutions. It's not there has not been change. There has been large-scale change in this country. You know, all of us know, who met our grandparents, know that the attitudes, social attitudes of people have changed. Their attitudes to life has changed. Our lives have are very, very different. You know, even what we conceive as truth, of equality, etc., from that of our grandparents. But you know, prescriptive social revolutions have actually not succeeded in this country. And it is my view that the constitutional morality, as has been interpreted by the Supreme Court, goes against the spirit of the Constitution, which I think in many ways, you know, as Baba Sahib Ambedkar also spoke about it, and he spoke about it a number of times when, you know, it was suggested to him that we insert values in the Constitution. He rejected it, and it's not that it wasn't attempted. He rejected it, and very interestingly, he all the values which could be at the forefront of a value-laden constitution were taken out and put into the directive principles of state policy. And directive principles of state policy are filled with sort of values in the constitution. But it was felt at that point of time during the framing of the constitution that we had to keep values in a separate packet, and we had to ensure, unlike the fundamental rights, which belong to everybody in person, you know, these values were not legally implementable. They were, of course, the governments were supposed to sort of bring them into law, but they were not by themselves legally implementable. The reason why it was felt, and why also Baba Sahib felt that, is because they didn't want to burden the constitution with values. Now, what is happening is, with constitutional morality, the idea of constitutional morality adopted by the Supreme Court recently, is there is an attempt to bring in values which were not included in the Constitution back into the Constitution. And I would only say that that is not a path which is envisaged in the Constitution. And in many ways, it is a road which we should all be skeptical about, because on very many reasons, as Symbiosis has shown, it doesn't work, as well as because, most importantly, it goes against the very, very nature and spirit of the Constitution. And lastly, in conclusion, this is something which we should all think about. Our judiciary has been envisaged, as Keshavananda Bharati said, to ensure that the institutions of governance are protected. Our the judiciary adopting an explicitly, in many ways, political stance by proposing social revolution through constitutional morality is something which has not ever been envisaged in the Constitution. It requires a very long and hard look at ourselves as well as institutions of governance, as parts of anything. And this is not, and I'm not saying this as an additional Solicitor General, and I'm saying this very, very clearly. I'm not saying this representing and talking as a representative of the government, but as myself. I think it is very important for us also to sort of discuss as whether it is acceptable in the constitutional framework that we have framed for ourselves that the judiciary performs such an activist role, using constitutional morality as the thin edge of the wedge to basically involve itself in politics, which the Constitution leaves for the legislature and the executive. Thank you very much.
Thank you, sir. Before we take the questions in the Q&A box, we have one live question from Mayuri Raghuvanshi. Mayuri, can you unmute yourself and ask your question, please? Mayuri?
We Q&A box. We'll bring up Mayuri back again.
All right. So then I'll take up the questions in the Q&A box, sir, one by one, till the time she comes back. Sir, yes. Sir, Dr. Madhukar Sharma, this you covered in your talk when you talked about social morality versus constitutional morality. But Dr. Madhukar Sharma wants to ask that when judges sit at a bench and interpret the Constitution, is it really constitutional morality or morality of the judges sitting on the bench? So he wants to
I think I've answered this. I think in the end, I've answered this very explicitly.
Yes,
very, very explicit.
Yes. So another question is, and I'll again from Dr. Madhukar Sharma, I'll take this. When societal morality comes into conflict with needs of the times, which demand for reframing of boundary, how to draw a line that changes should be enforced or not? For example, matter concerning to life and death of someone, then change should be enforced, like Sati Pratha, he gives an example.
Yeah.
Should it be enforced even if matter does not pertain to life and death of someone? So he wants to know your views on this.
You want me to answer that? I think it's a very simple answer, and I'll take Sati Pratha as the example. Sati Pratha was not declared unconstitutional by by the judiciary at that point of time.
Yes.
It was because there was a debate and people decided that it was unacceptable, and there was huge amount of literature and people came to a consensus. They worked towards this. They lobbied the government at that point of time, and changes were brought. The solution for making such issues, and there are no society is perfect. I think there are a lot of imperfections in society. The solution is not to go to the court, but to raise these issues, make these issues a very serious topic of discussion, and then to ensure that these issues then become issues on which the government is then forced to act. And it's happened. It has happened. Why only during the time of Sati? It has happened during dowry, for that matter. It has happened for banning of drugs. It has happened. It happens all the time. So I don't think, on female infanticide, it has happened. So it's not that it hasn't happened. On untouchability, so it's like, if you want it, it can be done, and it need not be done by the judiciary. And that's what my view is. Good, bad things need to be corrected. There is no doubt about that. But should the judiciary be doing that? That's my question. I don't think the judiciary should be involving itself in this.
Sir, a follow-up question for things where legislature has not done anything, something like Vishakha. Judiciary had to step up and lay down the guidelines.
I'll take that question.
Yes.
I think, question is this, that, you know, maybe it is easy for a lot of us to get things done through the judiciary rather than doing the hard way of getting it done through the legislature. I am saying that it is possible, and it was possible, in my understanding, to get even Vishaka done through the legislature. But a lot of us, you know, it was a shorter cut, and adopted that. You know, I think, are the guidelines relevant? Of course it is relevant. Do you think it wasn't in the works? I don't think it wasn't in the works. It was in the works. But of course, you know, before the legislature could come out with that, the judiciary came out with Vishaka. And do I think eventually the legislature, if we had pushed hard enough, and it would have been pushed hard enough, because more increasing number of women in the workplace would, you know, those issues would arise. And all of us know those issues would arise. And the legislature at some point of time, either the executive or the legislature, would have had to address those issues. We got it done through the judiciary first, because whatever, that's what I'm saying. Should it have been that activist? I don't know.
Right. Yes, sir. So I'll take the next question. It says it's been more than 2 years since Sabrimala judgment and we have failed to execute it. Did Sabrimala judgment prescribe to constitutional morality, except in light of the fact that women there don't want to violate the restrictions imposed via religious practices? You have covered this, but still, I think he wants you to revisit your whatever you have said.
Well, like I said, it doesn't work. You know, my crux of it is, if you were going to come up with an, you know, with a logic which goes against what the people believe, it's not going to work. And the reason why it may not work is because maybe it may not be the problem of the people, but maybe in the way you've interpreted the law. So, you know, we all have to be very skeptical of that.
Yes, sir. Also, one question has come on the 42nd Amendment and 40th Amendment, as it was. It says it was back in 1973 when court passed judgment in Keshwananda Bharti, stating and giving us the basic structure doctrine and saying that it's inviolable and cannot be amended by Parliament. But then 40th Amendment and 42nd Amendment added words in the preamble, removed words from the preamble, and brought other provisions, thereby violating the basic structure. So he wants to know your views on this.
You know, parts of what were violative of the basic structure has been struck down in Minerva Mills. So that's part of it. The parts which are left, some of them are being challenged. What I really don't think, since presently, because they're sub judice, I should be commenting on that, because for all you know, I may be appearing in those matters. So something which I shouldn't comment on that. But broadly speaking, on the procedural parts of it, the portions which the Supreme Court has felt needed to be struck down have been struck down. And if it feels that the other portions are also unconstitutional, which were part of that amendment, it will in its own course.
So one question has come with respect to judicial overreach and PIL, exercise of PILs. Yeah. Even though you touched it a bit when we were just discussing the earlier question. He says, do you think that the judgment of judiciary is compromised by legislature, or legislature's functions are being intruded into by the judiciary, especially in light of the PIL jurisdiction that the court?
I personally think that every court legislates to an extent, and the extent varies. I would say, you know, I would take a conservative interpretation of the Constitution, and I would say that the restraint is, after all, upon the judges, how much to restrain themselves or not. And I would be of the view that the more restrained the judges are in legislative action, the better. And I'm not a person who says that, you know, there should be Lakshman Rekhas legally drawn for judges to decide or not to decide. I don't contribute to that idea, but it is, but when you, as they say, when you perform your Raj Dharma, the person who performs their Raj Dharma should also know the limit, to the extent what is dharma extends to. This is something inherent, and should be within all of us.
Yes, sir. Thank you. So that's it from the question and answer box. Mr. Akshay, do we have any live questions?
None as of now, Mihir. We're waiting for attendees to raise their hand icons.
Yes. So one thing what people want to know, especially in light of view of things like imposing the human rights and other things that court regularly passes their judgments on. Do you think, especially in light of national security cases where people have a right to know or people may not have a right to know, do you think constitutional morality works there vis-a-vis national security cases and human rights in that context?
No, it depends on how you interpret constitutional morality. That's that's the whole question. Isn't it? If you interpret it in the terms of what Keshavananda Bharati says, where, everybody, all institutions respect other institutions, then that's perfect. Then that's okay. Then that perfect balance can be found. But if you use constitutional morality as a prescription for rights revolution, then that becomes completely different. I am skeptical of constitutional morality being a manifesto for revolution. I'm very, very skeptical.
So one question I had it in my mind, and I thought I'll ask you here, is that supposingly, since constitutional morality is not very well defined, but do you think its application sometimes leads to judicial overreach? And
So that's that's the basis of what I've been saying, and I don't want to say it very explicitly as what you were saying. I may not want to use those words exactly because I know how hot those words are. And I also have a job where I have to go and face them tomorrow. You may not have to have the job, but I have to face them tomorrow. So, but my view on that is very clear, that you can't use constitutional morality as a manifesto for revolution. Sorry, that is not envisaged. That is not part of the Constitution.
So thank you, sir. Thank you. I understand, sir, your answer to the query. So we have a couple of live questions. Dr. Madhukar Sharma will ask the live question. So
yes.
Good morning, sir.
Morning.
Most of the questions have already been answered by you, and it took some time for me to get back to you with some other question.
Yes, sir.
Sir, this question on morality, is it merely an academic pursuit, or do you people, because we don't know that what so happens in the courtrooms, or do you people argue on the constitutional morality before the Supreme Court judges as well?
No, as I said, Mr. Datar argued constitutional morality. Mr. Parasaran argued constitutional morality in Islamic education. So, so it's argued. It's not that it's not argued. It is argued.
Sir,
so it's not, let me put it this way. I'm being a participant in a large number of constitutional matters. The fleshing out of a lot of these conceptions may be done at the end of at the judicial end, but the seeds and the basis of these arguments are made by lawyers. And so the twists and turns which you see being taken, it would be wrong to assume that it's only judiciary which is gone off on its own tangent, because the judiciary in very many cases, even some judgments where I have skepticism of, have been drawn to those conclusions by very eminent advocates. And sometimes you would, as a participant, sometimes as a very younger participant previously, I would wonder how could such eminent advocates of such eminence, and I won't take examples, would do such things. But I guess that's the nature of advocacy. That's the nature of maybe their ideas of what they want to articulate before the court.
May I ask follow-up questions, sir? Me, sir?
Yes, please go ahead, sir.
So we the teacher community, maybe some of the student sit on the bench of the Supreme Court tomorrow, maybe arguing in front of the bench tomorrow. Definitely, we for that. So as a teacher, because you have already pointed out, sir, that that the judges should draw a line by their own self, rather some sort of legal uh, uh, line be drawn with respect to the self-regulation on the question of morality. We, the teacher community, how we should try to train the future judges or the future lawyers, so that 5 years hence or 10 years hence or 20 years hence, we may have a feeling that, okay, fine, there is some sort of self-regulation among the advocates as well as among the judges.
Well, that's a tough, very tough question. That's an incredibly tough question, because I have great respect for teachers. My teachers have inculcated most of my values as both as a lawyer as well as a human being, which is very, very important. I've been inculcated by my teachers. And it's very difficult to inculcate these values, because it eventually does not have, it is partially, let me put it this way, it is eventually partially only dependent upon what is taught in class, as to academically what is taught in class, but it is also as to what is the outlook of the person when he sits on the bench. And all of us then twist our logic, whether we are lawyers, whether we are judges, to justify the conclusion where we have already come in our minds. So, to be able to come to a framework where you want to cede power, when you can exercise power, don't want to exercise that power, that requires a large amount of self-restraint. And self-restraint, maybe in our grandfather generation, was inculcated from the very beginning, and grandparents' generation, maybe the generation before that, inculcated. People were themselves hugely restrained, and they believed in this entire attitude of self-restraint. I don't think our generation is very known for being restrained. So to give up an opportunity of exercising power, however small, however insignificant, or however significant, is something we don't give up easily. So as teachers, I think the greatest thing which can be done is to teach people self-restraint, which is partially. The other is the academically, to maybe teach that Constitution has to be interpreted conservatively. And there are enough sort of books and texts through which one can do that. But the most important thing is to teach self-restraint. And that I think only teachers can do that. I don't think anybody else can do that, because I don't think the person concerned will ever learn these at chambers, because lawyers being lawyers and advocates being advocates argue the maximalist position most of the time. So restraint is something which lawyers, at least, I don't think are known for.
Thank you, sir. Thank you.
Thank you, sir. Mr. Shaumik Ghoshal. Shaumik, can you please unmute yourself and ask your question?
We'll come back to Shaumik. Meher, we can take the other questions.
Yes. Mr. Arjun Chaudhary, can you unmute yourself and ask your question?
Mr. Banerjee, I hope I'm audible to you.
Of course.
Well, thank you, panel, for allowing me to ask this question. Mr. Banerjee, it's a pleasure to hear you speak about the influence of Hellenism on our culture, especially our constitution as well, when it comes to deciding what is right and wrong. So my question is, what is the shape, in your opinion, of constitutional morality in the time of healthcare crisis by the judiciary and the executive, where questions of right and especially liberty has come into question? Is it flexible? Is it rigid? Or is it a combination of both? Thank you.
See, thank you very much. This is a difficult question on one side. On the other side, it is, in many ways, I think the present pandemic is a decent example. I think in many ways the best thing, and to its credit, the judiciary did was to consciously, and I say this very consciously, stay out of the management of the pandemic. I know litigation was filed saying that direct ICMR to direct the hospitals not to use chloroquine. There was a writ petition. There was a writ petition filed, Article 32, asking the judiciary to direct people not to use chloroquine. But to its great credit, judiciary kept out, because other people are equipped to do that. The executive is equipped to do that. And I think that should be, the judiciary knows exactly in what places there are things have gone wrong, which is to be corrected. Places where maybe nudges are important to ensure that the executive does something. But to get into areas of litigation, of legislation, is something which, especially in times of healthcare crises, where the judiciary is very ill-equipped to handle these issues, is to be involved. Judiciary should stay out of it as much as possible. Of course, impossible that it should stay out completely is an impossibility, because every government action would possibly require some sort of oversight, at least in theory. So, but it has consciously chosen to stay out of it to that extent. And I think, in spite of the great provocations which it has faced, it's done a decent job on that.
Thank you, sir. Mr. Chaudhary, do you have any follow-up question?
Well, yes, I do. I hope I'm audible again.
Yes.
Go ahead.
Of course.
Well, Mr. Banerjee, I have another difficult question for you. It's a follow-up, as Mihir just suggested. What is the status of employment law in this time of crisis, where it is not just issues regarding being raised about the employer's responsibility, but also the employees' duties to the employer in terms of the quality and quantity of work that they're doing, and movement of labor, and the movement of labor?
Yeah, see, there are two aspects of it. I think I know what you are indicating, and I know that these questions have come up, are presently before the judiciary, before the courts, and I don't think the courts have, on various issues, they've been faced with it. The courts have not come to a conclusive finding on that. I would rather, if I'm not in their shoes, so I can't decide on their behalf, but if I theoretically, in an alternate reality, if I were to decide on such issues, I would stay out of it. I would nudge possibly the executive to come out, to sit with all sides and parties to come out with a solution. It is not a space where, the judiciary is equipped. It is not a space the judiciary can effectively change things on the ground, because it has no power of supervision of how things work out on the ground as well. So it's better that someone who has the ability to go in for larger scale consultation, has better idea, as well as experts, as well as stakeholders, can, sort of people who can get everybody involved and pass that, sort of come out with a solution. And I think the executive, to that extent, is the best equipped. So I think, to an extent, the judiciary has creditably not gone into these issues, and has tried to nudge the executive to sort of solve these issues, which is creditable.
Thank you, sir. Mr. Chaudhary?
Well, I had two difficult questions that I asked Mr. Banerjee, and I have another follow-up question if the panel allows, which I think maybe Mr. Banerjee can speak on at greater length in this program. Sir, do you believe that the common law tradition has greater continuity now, or do you think we should revert back to civil law traditions where there's strict interpretation of statutory law so that there is easier administration and management of the nation and litigation for that matter?
We've never had a civil law background. I think maybe only with the exception of maybe Goa and certain French enclaves, and in India we've had civil law. Largely, we've had common law, which is practiced in most of our courts. That is something which we've adapted to for the last 200 years. I don't see any reason why we should give that up. It has served its purpose. Because one of the great things of the common law system as compared to the civil law system is, justice not only has to be done, but it has to be seen to be done. But I know there are a lot of disadvantages in the common law system. It takes a lot of time, it's inconclusive, etc., etc. But at least there is a perception that justice is seen to be done. That's extremely important I've always thought, in a country as diverse as India, diverse on various different issues and various different parameters. So yes, maybe civil law system may be a little bit more efficient. So I don't know how it would work in practice in this country, which is very, very different from as to demographic composition from countries of Europe or Latin America, or even in Russia, where it's different. Number of people are different. The diversity is, I would say, is much less, with the exception possibly in Russia. But otherwise, I don't know how much of it would actually work in practice in India. We've adopted and adapted common law system to suit ourselves, which is different from the common law system which is today practiced in Britain. And to that extent, it is internalized. And a little bit of history understanding is also to be, it would be worthwhile. The greatest contribution, at least before the 1920s, before the British Raj became explicitly racist in large number of its policies, the common people, and the reason why people had a faith in British Raj, and we can't disregard the fact that at some point of time people had faith in the British Raj, was not because it brought in railways or because it brought in modern medicine, but because people respected the rule of law which the British brought actually in India. You look at any old books on history, contemporary historians, Indian historians, contemporary historians. I'm not talking about today's historians looking into the past, but contemporary historians, would always tell you it is, the greatest contribution was the rule of law. That's what the people felt. And you can understand some of our greatest nationalists, therefore, came from that background, because they came actually clothed in that sort of conception, as in the best the best people of the best products of. There were a lot of wrong things with the British, but the redeeming feature of the Raj or British Empire was always the law. And so therefore it was the barristers who knew how the system functioned, who were at the forefront of all this change. And even if you look at Bankim Chandra Chattopadhyay and those people who, and some of the initial people who spoke up against the British were actually part of the judiciary, and they were deciding cases, and it is they who for the first time put their finger onto this entire hypocrisy of Britain saying something in theory in relation to Indians, but practicing something else for the British. But overall, I can assure you that amongst all the institutions in India, even today, the people have most amount of faith is the rule of law, is law, with its huge disadvantages. I'm not saying it's perfect. Nothing is perfect in the world, but people still have faith in the law, and I wouldn't change it for anything else.
Thank you, sir. Mr. Chaudhary, Do you
I
have
can
any
ask
further
another
questions?
question if you want me to. Invariably, Mr. Banerjee, questions are raised about the British colonialism and the administration of law and justice in this country. But it has been since 1947 that we were granted independence. Do you think that our administration since then has been any better or worse? And what has been the constitutional morality of governance in this country since then?
I have no, let me put it this explicitly. There are two views now. One which holds as if everything was perfect during the time of the Raj and it was perfectly governed, and there is another view saying that everything was wrong at the time of the Raj. I don't contribute to it. I think if you read contemporary writings of the Raj, even of the 1920s and 30s, you would hear the same criticisms, including corruption, which you hear about judges in the higher judiciary also, even at that point of time. So this was not unusual. You would hear about violations of constitutional morality, of high functionaries of the state being susceptible to all sorts of things. So, I don't think that, and I don't think that the 1950 constitution that we've had is in any way a major break from the system of governance that we've had on the British. In fact, the large portions of the 1950 constitution is borrowed from 1935 Government of India Act, which is a culmination of a large number of legal thinking in British India. And I'm not talking this as the British gave it to us. It's like there was huge amount of discussion with Indians at every step of the way of people of that point of time who formulated this sort of governance. Was it any better? I don't think it was any better. Were there no imperfections? Of course there was. And I don't think we are any better or any worse. It's just that we are more populous as a country. So therefore, since we are more populous as a country, we have possibly more examples of it. But I can assure you that any contemporary reading of those times will show that it was not better in any way. The allegations were still there, both for the executive, the legislature, as well as the judiciary. It's another matter that we, post-independence, we have either deified, made gods of our nationalist leaders, or vilified them or made them villains. They were all humans like all of us. And people before them were all humans. They were not demons like all of us. They were trying to run a country. They were taking decisions. They were taking governance decisions in this very diverse country. And they were humans like all of us. So in any ways, I don't think it's better. I think constitutional morality was better or worse. It was just what it is. But in nowhere, till the last few judgments, that's the crux of what I'm saying. Nowhere, except in the last few judgments of the court, was constitutional morality a prescription for social or political revolution. That was never there.
Thank you, sir. Thank you, Mr. Chaudhary. Mr. Vikram Singh, can you unmute yourself and ask a question, please?
Good afternoon, sir.
Good afternoon.
Sir, it's not rather a question, it is simple sort of submission, or I seek your opinion upon this. Sir, as far as my little understanding goes, that is the constitutional morality is actually an overall equity of the constitutional principles.
Yeah.
And which are, in the modern sense, I can say that there can be said to be constitutional morality only when they justify the third dimension of the rule of law of Dicey, that is predominance of legal spirit. Because constitutional morality only erupts when there is silence of law, or even the constitutional principles are silence over the aspect. That's why we had a doctrine of basic structure. Now, moving ahead, my simple suggestion is that constitutional morality in present times is being sort of sidelined by the social workings, and the judicial process is itself finding itself in minority, because the way the executive process, usually constitutional morality is said to be function of judicial process, but actually in the workings of the things, it actually comes out as the it actually is being overtaken by the executive process and the academic process. This is my point of submission, because recently
my take on that is, we have to really understand and question is, if you go by both the idea of growth actually says constitutional morality is a respect for institutions of, political institutions by the citizens of the country. Dicey spoke about that, different institutions respected each other. It's an unwritten respect for other institutions by different institutions. So it was an instrument or an idea which sort of inculcated governance rather than a prescription for conducting change. Now, the question as to whether it's the job of the judiciary, I don't think it's the job of the judiciary. I think it's the job of everybody else. I think everybody has to, sort of discuss and inculcate discussion of constitutional morality in their workings. And as Baba Sahib Ambedkar said, it has to be cultivated. But the problem is this, the crux of the problem is this, is that judiciary has an interpretation of constitutional morality. And especially now, as I said, of a social revolution led by individual rights. Maybe our constitutional morality is not that. I think the conflict which we are facing is not that there is a lack of constitutional morality amongst the participants. It is maybe the interpretation or the belief of judiciary that constitutional morality is X, while other institutions believe constitutional morality is Y, is the reason for the conflict. And I would say the judiciary's interpretation of what constitutional morality is seems to be even today at variance with what the constitutional morality which people think is. That's something which we all have to wonder and think about.
Yeah, sir. I was on the same point, but my query was this: that how to get this balance? Because when executive process in delegated legislation is not respecting the constitutional principles, and even in the academic discussions, it's being sabotaged. Then what can be the role of judiciary? Because judiciary has to keep an eye over that aspect as well. Because very recently in 2018, I have read an article in the Annual Survey of Indian Law, and it is saying the way the Supreme Court of India has been reading the principles of the Constitution, it is actually imbibing the Western philosophy in the name of equity. And the judgments of Josephine Shine and the judgment of Navteej Singh Sarna, they were, and K.S. Puttappa, they were being sort of being criticized. Wherein, if we look actually in those judgments, they are putting the weaklings ahead in the line. Actually, they are empowering the weaker sections of the society. But this person, I won't name him, he was saying that it is sort of distorted understanding on the part of Supreme Court, because Indian culture is being sidelined. Wherein,
as I said, I have a conservative approach, and I'm not passing value judgments as to whether adultery or 377 is against Indian culture or not against Indian culture. I'm not going into that debate. I'm not going into that debate explicitly. That's a debate which people should have had in the legislature, which should have had in the executive. See, I can understand at least something from to that extent as to triple talaq, because triple talaq, there was no legislation either way. And so to that extent, it was a customary practice in which the court said it goes against. But it chose not to say that it's against fundamental rights. But for other things, 377, 497, these were parts of the Constitution. These are parts of the Indian Penal Code. If there was sufficient belief in the people that these are provisions which are unacceptable, then I'm sure the government would have then changed it. It's not that it hasn't changed. We know only recently the definition of rape got changed, extensively got changed. So it's not that IPC is not changed, but there would have been some reason the court, in its great wisdom, thought it could change it, tweak it, based on the ideas of its personal ideas. And I must say this, as I just mentioned it in passing, at the end of the day, large parts of people in the profession are products of a Western educated system, of Western values, which come with part of that education. It happened with me, happened with everybody else. But how much is that valid when you apply it to the real India? I'm skeptical, but I'm willing to say that maybe they are right. I may not agree to that, but I'm saying maybe you're right. But then that should have come through the executive, because the executive is answerable, and should have come to the legislature, through the legislature, if it really reflected that change. But that hasn't come. Judiciary is, as I said, cannot, again, the ideal role of the judiciary in terms of the constitution is not to perform this role. And to twist it in another way, I would say that I think in terms of Baba Saheb's idea of constitutional morality, maybe the judiciary is not perfectly acting in accordance with that. Because it should, if it was, respect other institutions as well.
Thank you, sir. We'll take the next question now. Mr. Swami Ghosha, please unmute yourself and ask your question.
Good afternoon, sir. Nice to hear you after a break, because since March we have not had a chance to meet you, which is quite unfortunate. Yeah. So my question is this: that we can sort of agree that basic structure doctrine, which has been laid down by the Supreme Court, to a certain extent has been referred to in so many judgments. It's become a little bit of difficulty understanding what are the contours. Almost 700 odd Supreme Court judgments have now referred to the basic structure doctrine after it has been laid down, which is quite a huge number. Even if you ask a jurist or even if you ask a law college professor to say what are the contours, it will be very difficult. It'll almost be like a thesis. We can understand that a doctrine like constitutional morality also may lead to that kind of a conundrum. But what do you think is the answer to the aspect of the Constitution of silences in the Constitution? There are inherent silences in the Constitution. This is also something which has been...
I don't think there is an inherent silence. I think every written document, any written document, whether it's a book, whether it's a deed, whether it's a contract, whether it's a constitution, whether it's any law, has areas which need to be interpreted. So yes, it has to be interpreted. It has to be interpreted in consonance with what are the existing parameters. You cannot invent, as I said, constitutional morality itself, if the idea is taken as it was originally formulated. It's perfect. There was no problem that every institution will respect every other institution. All high functionaries should respect other high functionaries. Everybody should respect the hidden understanding behind the Constitution. Perfect. There is no problem. The issue arises is when you start reading in social revolutions as part of constitutional morality. And then you start interpreting the law in terms of that, and then you start sort of highlighting fundamental rights and the ideology of fundamental rights, not merely fundamental rights, but the ideology of fundamental rights as the engine of this revolution. And then you start striking down laws based on that. And customs, which are like these laws, I think nearly 1860s, so 1960, 150-year-old laws based on these things, based on this new idea which you've conceived of, or practice, or customary practice which goes back thousands of years, hundreds of years back. then that becomes dangerous. It becomes dangerous. And I think that what the court did in Shaira Banu, and the reason why Shaira Banu seems to have been accepted as compared to SADGAMAYA is showed the sagacity of the court, even though it was tempted to go into constitutional morality. But for whatever reason, and I indicated some of the reasons what I think was weighed with the court because of its experience before, but the court did not go down that road of testing triple talaq on constitutional morality. So, constitutional morality and silences and the right of interpretation, of course you should, and there's nothing wrong in it. But the problem is when it becomes a ideologically loaded, that's the scary part.
Thank you, sir. Thanks a lot.
Thank you, sir. Mr. Balram Pandey, please unmute yourself and ask your question, please.
Thanks a lot, sir. Good afternoon, sir.
Good afternoon.
Sir, my question goes like this, that, we have given many contemporary meanings to the term constitutional morality. And one such contemporary meaning which I found by virtue of Supreme Court judgments is that it has enabled courts to look at the spirit, soul, and conscience of the Constitution while testing the validity of government actions, as you are also saying. So in this sense, constitutional morality is the second basic structure doctrine and is no more or less, as the Honorable Attorney General said, that it is no more or less dangerous than the basic structure doctrine itself. So
yeah.
What I want to ask is, as Dr. B.R. Ambedkar said in the Constituent Assembly, that constitutional morality was not in his formulation meant to be used as a test by courts to invalidate legislations or government actions.
Yeah.
And this was also fairly Groth's idea of constitutional morality.
Yeah.
And it was a rhetorical device which was used by Dr. Ambedkar to justify why seemingly mundane details about the administration the administration of government had been included in India's constitution.
Yeah.
So, sir, my question is that is it not a counterpoise to popular morality? The term constitutional morality.
That's the question. See, if you look at what Keshavananda Bharati did, I understand where you're coming from. I think if you look at Baba Sahib's speech in context, independently, and when Baba Sahib also spoke about, if you remember that speech, also speaks about toward the end that you have to cultivate it. You have to cultivate constitutional morality amongst the people. He said that very specifically. So if you take that into account, possibly there is a conflict. People's morality and constitutional morality may be different. But when the judiciary first takes it and interprets sort of constitutional morality, quoting Baba Sahib Ambedkar, quoting Groth, I think more or less from the same paragraph, it quoted Groth, because that's the standard paragraph everybody quotes, and then quoted Dicey. Keshavananda Bharati goes and says that, there are these hidden silences, these issues which, the hidden understandings of the Constitution. And everybody should respect these hidden understandings. And every institution should be conscious of its role. And therefore, I assume, therefore, of its duties. So if you look at it in that manner, which was interpreted in the common law, as reflected in the Keshavananda Bharati matter, and then few judgments after that, I think Manoj Narula as well, then it seems like there is no conflict with popular morality, because popular morality has a different, public morality has a different field completely than constitutional morality. But the third is what the Supreme Court has now done, is gone beyond Baba Sahib Ambedkar and then made it as I said, I quoted paragraph, right? Sort of revolutionary manifesto. I don't think it's a revolutionary manifesto. I'm very skeptical of that. Do I agree with Baba Sahib Ambedkar view? We know the context in where Baba Sahib Ambedkar actually said that statement. So to that extent, it was in many ways it was limited. He didn't talk about it broadly. So it's, I think the context which he said was that you have to inculcate the respect for institutions, because Baba Sahib Ambedkar was in many ways a conservative institutionalist. He believed in that the institutions of state needs to be respected, because you've seen his attitude also to agitations and extra constitutional agitations. So he was in many ways conservative on that. So I would say that he was right in his own way. Keshananda Bharati was right in its own way, but both of them certainly did not mean what the court has made it out to be.
Thanks a lot, sir. A very beautiful explanation.
Thank you, Balram.
Thank you.
So we have another question from Aishani Shukla. Aishani, can you unmute yourself and ask your question, please?
Good afternoon, panelists. Good afternoon, sir.
Good afternoon.
So my question has more or less been touched in the last question that Balram asked, but I'd still put it forward. Sir, in my opinion, we can, while upholding the variety of cultures and the different societal structures that exist, in my opinion, the provisions of the Constitution provide for all of these things, while making it constitutional morality the basis for a social revolution. Why, sir, in your opinion, is constitutional morality cannot form the manifesto of social revolution?
But for me, is constitutional morality as a concept can be the basis of any social revolution, whatever you want to. But is the constitutional morality of our constitution reflective of social revolution? If that is the question, I don't think so, because that's not reflected in the Constitution. Because the Constitution consciously took out all the values and put it in directive principles of state policy. It was a very conscious decision, because all of us know at the time there was huge debate on whether these values should be put, whether values at all should be put in the Constitution. Baba Sahib Ambedkar, again, all of us read the Constitution, are aware in that a very famous debate about incorporating socialism and secularism as amendments into the Constitution by K.T. Shah, actually got up and said that we don't want values into the Constitution. These are values we don't want to burden the future with. So I would like to say that our Constitution is value neutral in many ways. And that's the reason for this longevity. While if it was the greatest danger of a Constitution is to be packed with values, because then there is automatically a conflict within. And of course, you can have laws, and because the reason why a Constitution should be value neutral is because the Constitution is the basis on which government is made, where every decision of the government is made. You can have government decisions which have value, which are based on values. You can have legislation which are based on values. But because of the nature of legislations and government decisions, these are by nature, therefore, easier to amend and easier to change. And it can be changed by a different set of people who've been elected in your place and change it. But a constitution, being a constitution, is permanent. And so therefore, I don't think that's the value, or that the constitutional morality of our constitution talks about any values as such. It's especially not this kind of a value. If you want this kind of a revolutionary changes, I'm not saying that you shouldn't want it. It's up to you. I may disagree with you, but you are entitled to want them. Then the solution, at least under the constitutional structure that we have today, under the constitution that we have today, then your solution is to go get people elected who will make these changes. It is not through the judiciary where 5 people on both sides appear before a court of 12 people, and the basis, the fundamental understandings of the Constitution is changed.
Thank you for your answer, sir. Thank you.
Thank you, sir. Thank you, Aishani. Sir, one question has come, and I'd like to pose from Mr. Alok Kumar. And he wants to ask your opinion on this. He says there are 2 schools of thought. One school says law is dynamic and ever changing, whereas the other school says that certainty of law is the hallmark of democracy and legal system. How does one balance it?
I think no law is permanent. No law is no legal system is permanent, and no legal system is completely fluid. If any legal system is completely fluid, then it's not a legal system. Then it's not a system. A system which is completely fluid is not a system. Every legal system is rigid at some level, at some point of time, and every legal system cannot be completely rigid, because if it is completely rigid, then it stops being relevant. It changes. Every legal system changes. It changes all the time. Judicial interpretation, application of law, executive interference, interpretations, academic interpretations. So, there is no, but the balance has to be, in the end, the fine balance, which is part of constitutional morality, as per, I think, Manoj Narula as well. The fine balance in the constitution is something, eventually this balance has to be decided by the judges. So I think if you ask me what is the relevance of judges in constitutional morality, I would say is to maintain this fine balance. Again, going back to the same thing, I think I've hammered it like 150 times. It's definitely not to propagate revolution. That's for wonderful people who demonstrate usually on campus. It's good for them, and 3 cheers for them. I may not agree with them, but they're entitled to their views. But that should not be the governing sort of manifesto on which the Supreme Court or the courts of India should operate.
Just got one more live question. Dr. Mohit Sharma, please unmute your question.
Good afternoon to you, sir. And first of all, thanks, sir, for providing such a great knowledge, sir.
You have to be louder, Mr.
Sharma.
Sharma.
Louder, yes.
Sir, am I loud? Am I audible?
Now you're fine.
Yes,
now
please.
you're fine. I can hear you.
Okay, sir. Sorry for that, sir. Sorry.
No, not at all. Not at all. It's my fault, possibly.
No, sir. It's my fault. Okay. Sir, I just want to know only one thing, that as Dr. Ambedkar said, that constitutional morality would mean the effective coordination between conflicting interests of different people and the administrative cooperation to resolve them amicably without any confrontation amongst the various groups working on the realization of the ends at their cost. And while talking about the constitutional morality, sir, I think there are two different things. One, the freedom, and second one is self-restraint. But right now in current present scenario, each and every person talks about the freedom, but they forget that the self-restraint is also necessary. So,
No, I agree with you. I agree with you completely, because when Baba Sahib, he spoke about that, you have to consciously cultivate this, and it's extremely important. I think the understanding, as I said, is very Burkean. Burkean is, I don't know how many of you, I'm just for contextualizing it. Edmund Burke is one of the greatest constitutional thinkers of British common law, and the sort of founder of conservatism as an idea. And Edmund Burke wrote at the time of the French Revolution, which he sort of condemned was a bad thing. And he wrote on 3 subjects throughout his life. One was on the American Revolution, which he said was a good thing. One, which he said was a conservative revolution, trying to protect the good things in common law. The other was, he spoke about the French Revolution. The Brits, how much they love the French. So anyway, he was of the view that everything which was wrong happened at the time of the French Revolution, because all law, all structures, the whole structures was destroyed. And the third, interestingly, he wrote a huge amount is on the East India Company's governance at that point of time in India, where he said the East India Company has destroyed the entire conceptions of Indian governance, and horrible. It has been a horrible. And he was the prime mover for the impeachment of Warren Hastings. So Edmund Burke actually believed exactly what you believe, that, it has to be, people have to, it is a conception of rights and duties. And it is duties as much, which are, the exercise of your rights are predicated upon your exercise of duties. And the interlocking web is what makes truly a government function, and a government function amongst the people. So that was his view, and I think Baba Sahib to a great extent contributed to that. That in many ways, as they say, a large amount of, Britain didn't even have a fundamental rights till 2001 or 2002, if I remember correctly, when it incorporated the European Charter of Human Rights as part of the Constitution, in a legislation as part of the Constitution, so that it could be part of the constitutional law of Britain. Otherwise, it didn't have fundamental rights. It traced out different rights from different statutes. And it believed that if everybody performed their duty perfectly, you would have a perfect, you would have governance. And that's what happened. It ran for, for 500 years. It ran perfectly fine without having fundamental rights. In fact, one of the major arguments of fundamental rights, and I always say this, is I think Madison was said this, that who shall be so brave as to write down the rights of the people? Because I think Jefferson was the person who, in American constitutional law, was the person who was the biggest mover of the fundamental rights chapter, because Jefferson was in France, was deeply influenced. He was the American ambassador in France, deeply influenced, brought back fundamental rights. While Madison, who was in many ways more trained as a common law lawyer, was very forthright. And it's not that he didn't talk about the rights of the people. He realized, because that was the great conflict, and about at that point of time in common law, right of the king, power of the king, of Hobbes and Locke and this and that. So he said, who will be so brave as to write down the rights of the people? So the moment you write down any fundamental right means you restrict those fundamental rights by writing them down. So I understand all this, and I think it's perfectly valid that it is, as I said, the best way to talk about constitutional morality is to take it in the way which Grote talked about, and take it in the way which Baba Sahib talked about, which is possibly a popular morality, which permeates the people in governance and those out of governance, the little people and the important people all over the country, and citizens and everybody included, which talks about that being personally invested in the governance of the country and into the institutions which govern the people.
Thank you, sir. Thank you for such an enlightening and interesting and enjoyable session. So before we end this, I'd like to invite Professor Dr. Ravanle to give the concluding remarks, and thereafter my colleague Raj Kumar.
We've just got a live question request by Madhukar Sharma. I'm putting him on screen now.
Yes.
Thank you, Akshay.
Yes, we'll take up this question. Dr.
Yes.
Sharma?
Sir, if I am stuck in two conflicting interests and I maintain the status quo, which is correct in eyes of the law, but which may not be correct in eyes or in the sphere of my own morality. And if I maintain the status quo, does it mean that I have abdicated my morality?
No, not at all. See, there is a reason why we had the Constitution. There is a reason. See, you also have to realize this, that, according to me, constitutional law has evolved over a period of time in history in this country. Previously, the role of the judge was different. After we sort of came out with this modern form of governance, which I sort of take back as the model which we have today, goes back from the 1935 Act explicitly, and which is incorporated in our Constitution. Everyone has a role. Your role is, I may have a morality. I may think that as a judge that X person has murdered Y person. I'm quite sure of that. But if I can't get up enough evidence against X, then I have to acquit, whatever I believe. Similarly, a judge may view as a certain order is immoral, but the hands are tied if you are in a certain situation because you're a judge, because that's your role under the Constitution. It doesn't mean as a person, you cannot, as a right of a citizen, you cannot vote for a group of people who want to change that status quo. You are entitled, that's your duty, you should do that. But as a judge, when you exercise that, can you do that? I don't think you can, because that's the nature of the Constitution. That's how it has been built. That is how a Constitution functions. And that's what we all need to know. It is not, I am not saying that if you find something immoral, you can't speak about it. Of course you have to. You have to bring pressure, you have to bring change. But can it be done through the judiciary? No. Once you become a judge, then you restrict yourself in terms of the law. What is permissible, what is not permissible.
Thank you, sir.
Thank you, Dr. Sharma. Thank you, sir. And I would now invite Professor Ravande to give the concluding remarks. Over to you, sir.
Thank you, Mr. Vikramjit. Yeah, because morality is that word which has been often cited but not practiced by many. Rather, it is always has been seen by many that they see the morality in others that let him or her practice than myself. But with this, because how we have been taught at the schools, and as you said in the beginning, that this period gave us opportunities to meet the new people whom we never would have met. And I also have found my interest, which I carried in my school days, like reading more and relating it or finding it in the midst of book. And nowadays I'm trying to go back and learn more about Sanskrit as well. So I would like to relate certain things which I have just learned and relate it with not just constitutional morality, but with law and morality. And so, of course, constitution is an inept part of it. So when everyone, I will just read one verse which says, Yatha heken chakrena narathasya gatir bhavet, evam purushakaren vina daivam na siddhati. It means a chariot cannot move only with one wheel. So when we say law and morality, these are the two wheels. So one cannot function without the other. So is applicable to us, me and my desire. So what I want to do, so somebody says the desire drives me, or I feel that it's my desire which makes me work. But end of the day, we are one and they are just two sides of us. So law and morality, they stay together, they cannot be parted. But yes, they will keep on changing their roles. But then the question arises when we refer to who should do it, how it should be done, when it should be done. So what is the value of learning? There is a good literature on this. I'll read this. Yasya nasti swayam pradnya shasradnyam tasya karoti kim lochanabhyam vinasya darpanam ki karishati. What value is there of learning if there is no self-wisdom in one? What can a mirror render to him who has no eyesight? So morality cannot be restricted to time, cannot be restricted to place, because it evolves as the mankind or the humankind evolves, as our desires evolve. So if we just focus on the Constitution itself, it was said that there's two parts, and unfortunately, we have been taught greatly about part 3 and part 4 of the Constitution, and rest we are told that you study it yourself. Part 3 is said to be the fundamental rights, and nowadays people just talk about part 3. Part 4, it exists, it does not exist. Well, people have different thought on that. But part 4 of the Constitution of India comes with a good title, Directive Principles of State Policy. And if you refer to Article 37, it specifically says the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply this principle in making the laws. and what we have seen, because that shows the wisdom of our forefathers when they gave us the constitution. Though we proudly say with the people of India, but sometimes I feel that, do we really exist? Do we really care? Do we really bother what is with us? But we have seen several of those principles have been incorporated into the decisions and what we see. So so there was also that struggle which was happening, whether fundamental rights as of area, whether directive principles have the secondary role. So you start with, then it is settled that they complement and supplement each other. So is the case with me and my desire. So is the case with law and morality. They always will complement and supplement each other. But the beauty lies in the eyes of the beholder. So morality is that another beauty which also keeps on changing and people have. So what does it make? It makes it very important for us to understand when we say there is another verb which I would like to cite. So the importance of learners, like we all at different stage of our life, it becomes important. Yatra vidvajano nasti shlagya stra trapla dhirapi nirastapadape desha erandopi dramayate. Means where there are no learners, even one who is with scanty knowledge is praised. So all of a sudden we come across a thought and then people start feeling, oh, what a wonderful thought. But why can it not be discussed, studied more, analyzed, and then we go further? Than objecting to a thought, than projecting a thought, why can't we learn that from the thought and make it, if it is so helpful to the humankind? So then again, because end of the day, the humankind, I am part of it, so my desires, so is law, and so is morality. So, but we also forget one more point, that nothing is permanent, as you say. So the importance of impermanence cannot be rejected. Rather, we all should worship, because that does not allow us to become static. So the law does not remain static. So impermanence is the point which rather makes the law beautiful, and morality is that pivot around which this impermanence revolves. And accordingly, morality keeps on changing, so does the law, so does the application at the hands of the judiciary as well. So I would just read a particular part when it comes to the impermanence, how it is cited. This is something which I came across, and then I thought that it should be Kayaha Sannihitapaya Sampada Padmapadam Samagama Sapagama Sarvamutpadi Bhanguram. It specifically says that unions are attended with separations. So means we have to separate our morality from our thought, and we have to see the thought of other, and then we will realize what one is saying. And of course, morality cannot be restricted to me, my morality, your morality, his morality, that's morality. End of the day, when we talk about morality, we cannot forget Vasudhaiva Kutumbakam. We are one. So of course, we cannot relate with the thought of other, but morality is for everyone. So we have to stick to that. And yes, without morality, this is my understanding, law cannot exist, because law is there not for the subsistence or the existence of the human being. Law is there for the governance by the people, of the people, for the people. So of course, and this is an offshoot of morality. So people, I hope, would realize, because in your talk, you touched upon all these aspects, and that is the learning which I got. But yes, at the same time, I would say that, nothing, we cannot just expect the state as a part, legislation, executive, and then the judiciary to do. We owe that role. We owe that role to ourselves, because we cannot be successful. We cannot bring in this morality or law, the effectiveness as part of our well-being, unless we work for it. And there is a very good proverb on this, which I would like to read. Udyamena hi siddhanti karyani na manorathai nahi suptasya simhasya pravishanti mukhe mruga. What does it mean? It says undertaking succeed through industry, otherwise not by mere expectations. We just have expectations. So I go back to that. Now we just know fundamental rights, directive principles. Oh, yes, they do exist. And then all of a sudden somebody comes, right to education has been made a right. But they have forgotten that it was a directive principle for the state itself, that as the situation, because when we gave ourselves the constitution, the times were different, but morality did not allow those provisions to remain redundant. And those provisions rather have made us realize, and we have rather actuated and given effect to that. So there are series of provisions which we have seen. People talk about 39 clause B, clause C. There are series of legislations after the independence wherein that has been taken care at the central as well as the state level. So people have to study this. Now, recently when the judgment and there is a specific mention of the term, I think people, instead of relating with the term, should understand the term, should understand the philosophy behind the term. People should understand the meaning and its importance for ourselves. And then we will live the law. We will not live the law unless we learn the law. And for learning, you don't need to go to the law school. But yes, among us only we can practice and we can respect each other. And that's the best thing which happens. And law and morality is the best thing, which was an outcome of today's discussion. And before COVID, if anybody does any research, this should have been the most searched word, morality. If you see in the last 2 years, you will come across, because what is morality? People come with one's morality, others' morality, state morality, and then the private morality, public morality. But instead of that, respect for each other, learning with each other, being together, understanding each other. And there is a term called samabhavana. Samabhavana is morality. Sadbhavana is a step towards it. And what we achieve is togetherness. And that is called Vasudhaiva Kutumbakam. So thank you very much for touching this chord. And you made me again go back to the school days and realize this. And I know sometimes, but I think Constitution needs to be understood in totality and not in parts. Because though it is referred there as part, that does not mean that we have to read it as part. We have to learn it together. And then only we'll understand the term, we the people of India. And because it stands for the morality as well. That's what my feeling is. So thank you very much. I enjoyed the session. Thank you very much, sir. Over to you, Raj.
Thank you, sir. Sir, on behalf of organizers of the knowledge series on law and justice and all the participants, we thank you for gracing the occasion and a topic which was so difficult, and you simplified it and made us understand the constitutional morality. So thank you so much, sir. We would also like to express our gratitude to our broadcast partners for the knowledge series on law and justice, Lex Witness, THS, the law firm, SADGAMAYA, and special thanks to Professor Dr. CJ Rawanle, sir, who's also our mentor, for providing this platform for everybody to learn from the eminent personalities of our profession. And I would especially like to also thank my colleague, Mr. Kumar Mihir, for moderating this session so well, and Mr. Akshay Alag from Lex Witness for the back-end support. For all the participants, thank you so much for attending this. And we will be back again next weekend with more and more eminent personalities. And for those who missed today's session, you could watch the video on the YouTube channel of our Symbiosis Law School, Noida's. So you can watch it there. Thank you very much. Thank you, sir.
Thank you.
Thank you so much, gentlemen. Professor Rawanle, seeking your permission to end the webinar now.
Please do. Thank you very much, Mr.